Hello everyone. Mahatma Gandhi Vidya Mandir Sanchalit, MHG Junior College Malegaon Camp. Myself, Smt Kavita Meshram. Once again, welcome to all of you in class 12 of Commerce. So, today's subject secretarial practice. Today we will see the chapter number 3, issue of shares. So, let's see next point. Transfer of shares. What is transfer of shares? So, meaning of transfer of shares that selling of shares is generally termed and transferred of shares is a movable property and this shareholder has a right to sell his shares, so the transfer takes place. It is an important feature of the company. That's its shares are transferable. Section 82 empower every shareholder to transfer his shares in the manner laid down in the articles and in accordance with the various provisions of the law. And next point, statutory provision regarding transfer of shares. Next one, two parties. Two parties is a very important, so you can deal between two parties. There should be two parties to transfer. One is transferor, the person who transfer the shares, and transfer, the person to whom shares are transferred. Next, instrument of a transfer, section 108. Shares are a transfer with a help of transfer from the application for transfer of a shares must be submitted in the prescribed form called in instrument of a transfer. It must be duly filled, completed, stamped and signed by the transferor and transferee. The instrument of a transfer must be submitted along with the share certificate in the office of the company. Next one, application for transfer. Transfer or transferee makes an application for the registration of a transfer of shares. Transferor is the share who wants to transfer his shares, and the transferee is the person in whose favor these shares are transferred. Sometimes shares may be transferred part. In this case, the transfer shall not be registered unless the company gives a notice to the transferee to receive no objection to transfer. Next one, transfer by legal representative, section 109. In case of decided member or transfer executed by the legal representative of decided member is valid. Next, power of refuse a transfer. Board has to pass the resolution for transfer of shares, but director have a right to refuse a transferor of shares. The right of a transferor is restricted. And now A, when the transferee is minor. B, when the international transfer is malified. C. When a company has lien on a shares, for example, the company has right to recover any amount payable by the shareholder to the company. D. When the instrument of transfer is not completed. E. When the center government gives direction to the company not to give effects to the transfer of shares. Now next one, blank transfer. What do you mean by blank transfer? Blank transfer means when a member signs the instrument of a transfer without filling in the name of the transferee and hands it over to the transferee along with the share certificate, it is called blank transfer. Blank transfer is also where the transferor only signs the instrument of transfer and the rest of the instrument is left blank. Now next one, for transfer, where signature of a transfer is a right on the instrument of a transfer. A forged transfer given no title to the transferee. Company should not register such a transfer of shares. Now next one, procedure of transfer of shares. Verify the AA. Article of Association contain serves a matter as to the procedure of a transfer of shares. The security first verify the provision in the Articles of Association. And now number 2, instrument of a transfer. He will receive the instrument of a transfer. It is called the transfer form in common language. The form is available with a stockbroker and registers of the companies. He received it in the prescribable form. It must be completed, filled and signed by the transferor and transferee. It must be dated and stamped and submitted to the company's office along with the share certificate. Number 3, verification of instrument of a transfer. Security. Now important. So secretary has to verify the detail of a transfer after receiving the instrument of a transfer. It he is satisfied it is accepted and a transfer receipt is issued. A transfer receipt is a temporary acknowledgement given by the company as a proof of submitting the transfer from along with the share certificates to the company. For example, acknowledgement for receiving instrument of a transfer when the transferor holds one certificate for a number of shares and wants to transfer only a party, part of shares. Secretary issue a balance strict which states that share certificate has been received out of which few shares are allowed for transfer and transferring is entitled to balance shares. So next point, board sanction. So secretary forward the form to the board to approve the transfer. If satisfied, board pass a resolution for transfer of shares. Now next, registration of transfer. After the approval from the board, transfer details are entered in the transfer registers. The name of a transferor and removing and the transferee name is entered is the register of members. The new share certificate is the name of a transferee is issued at the company registered office or that can be sent to his home by post. And now important point, transmission of shares. What is transmission of shares? So transmission of shares, that a transfer of shares by the operation of law applications. So now then capable, application of law is called a transmission of shares. The original shareholder shares are transmitted only case of death, mentally disturbed person. Shares are transmitted only case of death and insolvency to the legal representative. The transferor is absent in case of a transmission. Regular transfer procedures is given is a section 108 of the Companies Act, whereas a section 109 takes about how regular a transfer procedure is not a foreign in transmission of shares. Instrument of a transfer. So transfer from is not used in case of a transmission of shares, but certain documentary evidence has to be processed by the legal representative for transmission. Transmission shares means passing of title to the shares by operation of law, inheriting due to a death, insolvency and launch of shareholder. Point number 1, in case of death, in the shareholder die after making the will, status the person named is the will, the legal heir, and the shares are transmitted to him. If he die without making the will, be administration appointed by court acts as a legal heir and shares are transmitted in his name. Point number 2, in case of mentally disturbed person, when the shareholder is linked shares transmitted to guardian of the shareholder appointed by the court. Point number 3, in case of insolvency, if the shareholder is declared insolvent, the person appointed by court as official receiver gets the share transferred in his name. Point number 4. If the joint holder of the shares, then the surviving member gets the shares transferred in his name. Next point. Provision regarding a transmission of shares. A provision regarding transmission of shares are given in the Regulation 25 to 28 of Table A. 1. Ownership of shares. When the shares are in a single name of the shareholder, the shares are transmitted to the legal representative. Number 2. Power of the board. If the legal representative does not comply within 90 days with information to transmit the share, the board had right to withhold the payment of dividend or any other payment on shares. Number 3. Right of legal representative. The legal representative has two options. A. He may get himself registered as a member of the company. B. He may transfer the shares to some of person. Number 4. Notification to company. Legal representative must inform the company about his decision to get himself registered as a member or to transfer the share to any other person. Next important point. Procedure for a transmission of share. 1. When the legal representative wants to get himself registered as a member. A. Receiving application. The legal representative writes an application to the company to enter his name is the registered of member. B. Security of document. The application receiver along with shares certificate of the said in scrutinized by the scrutiny. C. Board approval. If a proper documents are submitted by the legal representative, secretary sent those documents to the board for their approval. And D. Change in register. After the approval from the board of director, secretary enter the name of new member and cancel the original shareholder's name in the register of member. And now next, E. Dispatch the new share certificate. A new share certificate is given to the legal representative after all these formalities, and your chapter number 3 is finished.